This is Democracy Now!, democracynow.org, The War and Peace Report. I'm Amy Goodman.
And I'm Matt Taibbi. Welcome to our listeners and viewers around the country and around the world. Well, today we dedicate much of the hour to a conversation with award-winning journalist Matt Taibbi, who you may know from his reporting on financial crimes. Well, now Taibbi is back with an explosive new book that asks why these crimes have gone unpunished, as an unequal justice system targets the most vulnerable. The gap between what the poorest make and what the wealthiest bring home has reached levels not seen since the Great Depression, and the drug war has fueled the mass incarceration of the poor and people of color.
Earlier this month, attorney James Kidney, who is retiring from the Securities and Exchange Commission, gave a widely reported speech at his retirement party. He said that his bosses were too, quote, tentative and fearful to hold Wall Street accountable for the 2008 economic meltdown. Kidney, who joined the SEC in 1986, had tried and failed to bring charges against more executives in the agency's 2010 case against Goldman Sachs. He said the SEC has become, quote, an agency that polices the broken windows on the street level and rarely goes to the penthouse floors. Tough enforcement, risky enforcement, is subject to extensive negotiation and weakening, he said. Well, for more, we turn to our guest, Matt Taibbi, award-winning journalist, formerly with Rolling Stone magazine, now with First Look Media. His new book is called The Divide, American Injustice in the Age of the Wealth Gap. Matt, we welcome you back to Democracy Now! It's a remarkable, important, certainly needed book in this day and age. Talk about the thesis. What is The Divide?
Well, this book grew out of my experience covering Wall Street. I've obviously been doing it since the crash in 2008, and over again I would cover these very complex and often very socially destructive capers committed by white-collar criminals. And the punchline to all of the stories were basically the same. Nobody would get indicted, nobody went to jail, and after a while I started to become interested specifically in that phenomenon. Why was there no enforcement of any of this? And around the time of the Occupy protests, I decided to write this book, and then I shifted my focus to try to learn a lot more for myself about who does go to jail in this country, because I thought you really can't make this comparison accurately until you learn about both sides of the equation, because it's actually much more grotesque to consider the non-enforcement of white-collar criminals when you do consider how incredibly aggressive law enforcement is with regard to everybody else.
Now, you spent time with the poor and vulnerable people of color who've been targeted by this system. There was one case of a man in New York who lives in Bed-Stuy, standing outside of his home, who was arrested. Can you take it from there?
Yeah, sure. I was actually in a law office in Brooklyn, and I was actually waiting to speak to a lawyer about another case when I met this 35-year-old African-American man, a bus driver, and I asked him what he was there for, and he told me that he had been arrested for quote-unquote obstructing pedestrian traffic. And I thought he was kidding. I didn't know what that meant, and I asked him to show me his summons, and he pulled out a little piece of pink paper, and there it was. It was written, obstructing pedestrian traffic, which it turns out it meant that he was standing in front of his own house at 1 o'clock in the morning, and the police just didn't like the way he looked and arrested him. And this is part of the disorderly conduct statute here in New York, but this is one of these offenses that people get roped in for. It's part of what a city councilman in another city called an epidemic of false arrest. Basically, these new stats-based police strategies, the whole idea is to rope in as many people as you can, see how many of them have guns or warrants, and then basically throw back the innocent ones. But the problem is they don't throw back everybody. They end up swooping up a lot of innocent people and charging them with really pointless crimes.
There's a very comic scene where then he goes to court and he has a hard time convincing his public defender why he doesn't want to pay a fine for standing in front of his home.
Yeah, and this is something that I encountered over and over and over again, is that people who are charged with these minor sort of harassing offenses, when the state discovers that the case against them is not very good, they start offering deals to the accused. And when people protest that I'm not going to plead because I didn't do anything wrong, they keep offering better and better and better deals, and no one can understand why they won't plead guilty, because in reality most people do. They will end up taking
like all the bankers plead guilty.
Right, yeah, exactly. Of course it's completely the opposite situation and then the other side of the coin. But in the case of Andrew, the guy who was arrested for obstructing pedestrian traffic, he literally could not convince his own lawyer that he was innocent, and it took a long time before they got the judge to ask the policeman on duty if there was actually anybody else on the street to obstruct, and it wasn't until that moment that they dismissed the case, and it just took that long.
So let's talk about the other side, and I want to go to Attorney General Eric Holder. His remarks before the Senate Judiciary Committee last May, in which he suggests that some banks are just too big to jail.
I am concerned that the size of some of these institutions becomes so large that it does become difficult for us to prosecute them when we are hit with indications that if you do prosecute, if you do bring a criminal charge, it will have a negative impact on the national economy, perhaps even the world economy. And I think that is a function of the fact that some of these institutions have become too large. Again, I'm not talking about HSBC. This is just a more general comment. I think it has an inhibiting influence impact on our ability to bring resolutions that I think would be more appropriate.
That was Attorney General Eric Holder testifying before Congress. His remarks were widely criticized. This is federal Judge Jed Rakoff speaking last November at the University of Pennsylvania Law School.
To a federal judge who takes an oath to apply the law equally to rich and poor, this excuse, sometimes labeled the too big to jail excuse, is frankly disturbing for what it says about the department's apparent disregard for equality under the law.
That's federal Judge Jed Rakoff. Matt Taibbi, if you could respond, and then talk about the history of Eric Holder, where he came from.
Well, first of all, this idea that some companies are too big to jail, it makes some sense in the abstract. In a vacuum, of course it makes sense. If you have a company, a storied company that may have existed for 100, 150 years that employs tens or maybe even 100,000 people, you may not want to criminally charge that company willy-nilly and wreck the company and cause lots of people to lose their jobs. But there are two problems with that line of thinking if you use it over and over and over again. One is that there's no reason you can't proceed against individuals in those companies. It's understandable to maybe not charge the company, but in the case of a company like HSBC, which admitted to laundering $850 million for a pair of Central and South American drug cartels, somebody has to go to jail in that case. If you're going to put people in jail for having a joint in their pocket or for slinging dime bags on the corner in a city street, you cannot let people who laundered $800 million for the worst drug offenders in the world walk.
Wait, this can't be a parenthetical. Explain what you're talking about with HSBC.
So HSBC, again, this is one of the world's largest banks. It's Europe's largest bank, and a few years ago they got caught, swept up for a variety of offenses, money laundering offenses, but one of them involved admitting that they had laundered $850 million for two drug cartels, one in Mexico and one in South America, and including the notorious Sinaloa drug cartel in Mexico that is suspected in thousands of murders. And in that case, they paid a fine. They paid a $1.9 billion fine, and some of the executives had to defer their bonuses for a period of 5 years. Not give them up, defer them. But there were no individual consequences for any of the executives. Nobody had to pull money out of their own pockets for permanently, and nobody did a single day in jail in that case. And that, to me, was an incredibly striking case. I ran that very day to the courthouse here in New York, and I asked around to the public defenders, what's the dumbest drug case you had today? And I found somebody who had been thrown in Rikers for 47 days for having a joint in his pocket. Is
that even illegal?
No, in New York City, actually, it's not illegal to carry a joint around in your pocket. It was decriminalized way back in the late 70s, but what part of the now past stop and frisk, what they do is they would stop you and then they would search you and force you to empty your pockets. When you empty your pockets, now it's no longer concealed, and now it's illegal again. So they had in that year they had 50,000 marijuana arrests, even though having marijuana was technically decriminalized at the time. So my point was, here's somebody at the bottom. He's a consumer of the illegal narcotics business, and he's going to jail. And then you have these people who are at the very top of the illegal narcotics business, and they're getting a complete walk, and that's just totally unacceptable.
But back to this doctrine that you can't punish an entire company for the misdeeds of a few, because you might hurt the economy, you might hurt shareholders, pension, some of which are pension holders and pension funds and so forth. How do you get from hurting a company? How do you equate hurting an entire company to just not jailing a couple of executives?
Well, that's the whole point. They've conflated the two things. Originally, so this to answer the second part of your original question, where does this come from? Where does this doctrine come from? Way back in 1999, when Eric Holder was a deputy attorney general in Clinton's administration, he wrote a memo that has now come to be known as the Holder Memo, and in it he outlined a number of things. Actually, it was originally considered a get tough on corporate crime memo because it gave prosecutors a number of new tools with which they could go after corporate criminals. But at the bottom of it, there was this thing that he laid out called the collateral consequences doctrine. And what collateral consequences meant was that if you're a prosecutor and you're targeting one of these big corporate offenders, and you're worried that you may affect innocent victims, that shareholders or innocent executives may lose their jobs, you may consider other alternatives, other remedies besides criminal prosecutions. In other words, fines, non-prosecution agreements, deferred prosecution agreements. And again, at the time, it was a completely sensible thing to lay out. Of course, it makes sense to not always destroy a company if you can avoid it. But what they've done is they've conflated that sometimes sensible policy with a policy of not going after any individuals for any crimes, and that's just totally unacceptable.
Is it not the case that some of these cases are just too complex to explain to a jury?
Yes, and well, they are complex, and juries do have a difficult time with them, but they're not impossible to explain to a jury. I mean, I attended a trial involving bid rigging in the municipal bond markets where they obtained convictions. Now, that case couldn't have been more complicated. That was as hard as a case gets. And I actually watched some of the jurors fighting off sleep in the early days of the trial. That's how difficult it was. And in that case, amusingly, one of the attorneys for the banks got up initially, and he tried to defend his client's behavior by saying, when you call up if your washing machine breaks and you call the repairman and he tells you how much it costs, you just have to trust him what the price is, because you don't understand how to fix your washing machine, and we do. In other words, this stuff is so complex, you just have to take our word for it that we didn't commit a crime. But that excuse, I think that's a weak excuse that prosecutors give out. It's a cop-out for not taking on difficult cases. Rich or poor, black or white. If somebody has broken the law, you should want to go after wrongdoers, no matter who they are. And the fact that it's a difficult crime to prove should just be more of a challenge for you.
I want to turn to remarks by Lanny Brewer in 2012 about prosecuting large companies. At the time, he was the Assistant Attorney General. He spoke before the New York City Bar Association.
It's my duty to consider whether individual employees with no responsibility for or knowledge of misconduct committed by others in the same company are going to lose their livelihood if we indict the corporation. In large multinational companies, the jobs of tens of thousands of employees can literally be at stake. And in some cases, the health of an industry or the markets are a very real factor. Those are the kinds of considerations in white-collar cases that literally keep me up at night, and which must play a role in responsible enforcement.
That's Lanny Brewer in 2012, who was like #2 in the Justice Department.
He was the head of the criminal division, so he's basically the top cop in America at the time.
He was at the Justice Department. Of course, Eric Holder is the Attorney General, both from the same company. Respond to what he said, and then talk about Covington and Burling.
First of all, that whole thing about the innocent white-collar employees perhaps losing their livelihoods, keeping him up at night. I want to know what his response is to, the idea that maybe a single mother on welfare is going to lose her kids because she's going to lose custody in an $800 welfare fraud case. I saw so many of these cases that it was just overwhelming to me. Those are the kinds of things that would keep me up at night if I were the Attorney General, thinking about the consequences that ordinary people suffer when they are caught up in the criminal justice system. For instance, again, going back to welfare fraud, your relatives can lose their Section 8 housing. So if you're on welfare and you get caught in a fraud case that may just involve checking the wrong box or having one of your neighbors say that you have a boyfriend living in your house when you really don't. Your mother or your grandmother can lose their housing because of something like that. That would be the stuff that would keep me up at night. I mean, I wouldn't be worried about millionaire and billionaire executives who are working at these banks if I were Lanny Brewer. So that tells you a lot about the priorities of somebody like him.
And talk about Lanny Brewer, Eric Holder, where they come from, where they go back to.
So they both came from a law firm called Covington and Burling, which in the 2000s represented basically every single one of the too big to fail banks. They were also involved in the setting up of the electronic mortgage registry, so they played an enormous role in the subprime mortgage crisis. But here's the key thing about the presence of these two people and at the head of the Justice Department. Prosecutors, by and large, and I interviewed a lot of prosecutors for this book, they basically all have the same personality, the old school prosecutors. They're just, if you think of somebody like Elliot Spitzer, they're all like bulldogs. They just want to get their target by hook or crook. It doesn't really matter. They have this ferocious aspect to their personalities, and it's an admirable quality in a prosecutor. They're all kind of the same in a certain way. Cops are the same way. But in the 2000s, that kind of person started to be replaced in the regulatory system by a new kind of figure who tended to come from the corporate defense community. And their attitude was not, get their target at all costs. It was more, let's bring a bunch of people in a room and hammer out a solution where all the sides are going to end up walking out happy. And that's why we end up with settlements like the $13 billion Chase settlement last year or the $1.9 billion HSBC settlement instead of prosecutions.
Covington and Burling represented J.P. Morgan Chase.
They did, yeah, and a host of other banks that also were involved in non-prosecutions during this time. So, I mean, you have a whole bunch of people who are sort of at the top of the regulatory agencies, whether it's Justice, the SEC, the CFTC, maybe the Enforcement Division of the SEC, who all came from these big banks or from law firms that represented these big banks. And it's a very incestuous community, and just like you talked about with James Kidney, the SEC official who left, as a result of this kind of merry-go-round of people who all work for the same companies, and they're going to go to government for a while, and then they're going to go back to the corporate defense community after they leave and make millions of dollars. They're very, very reluctant to be aggressive against these companies because culturally they're the same people as their targets, whereas there isn't that same simpatico with the very poor, and I think it's an important distinction to make, and people don't understand it.
You also suggest that Holder and Brewer are perhaps overly concerned with their conviction rate, and that's why they're not go after these banks.
Again, that's something I heard over and over again from people within the Justice Department, that once those two came in, the edict came down from above that we were only going to go after cases where we were absolutely sure we were going to win. Now, and you can never guarantee a victory in any criminal case, and oftentimes the cases are difficult to prove, or the evidence may not be 100% there, but the state has a moral obligation to proceed with investigations, and in many cases criminal cases, against people who are guilty. The fact that it's difficult shouldn't be a limiting factor, and that's why you saw, instead of cases against these big banks, you saw ridiculously large amounts of resources devoted to things like prosecuting Barry Bonds or Roger Clemens, cases where there were like only a couple of pieces of evidence and it was hard to screw up. And yet, they didn't know we would succeed even in those cases. So it was a terrible, terrible thing for the Justice Department during that period.
We're going to break and come back to this conversation. The award-winning journalist Matt Taibbi is with us, formerly with Rolling Stone magazine. His new book is called The Divide: American Injustice in the Age of the Wealth Gap. When the government does go after banks, what banks do they go after? We'll talk about that in a minute.